I said, I understand you all have reached a verdict.
We have.
All right. You have the verdict form with you?
I do.
Can you hand that to the bailiff, please?
I will.
I'll ask the clerk to publish a verdict.
In the Circuit Court of the 14th Judicial Circuit in Fort Bay County, Florida, case number 22-608CA, Zachary Young plaintiff versus Cable News Network, Inc. defendant. Verdict form number 1. Do you find by the greater weight of the evidence that defendant CNN committed defamation per se against plaintiff Zachary Young? Yes. Number 2, do you find by the greater weight of the evidence that defendant CNN committed defamation by implication against plaintiff Zachary Young? Yes. Number 3, what is the total amount of plaintiff Zachary Young's damages for both lost earnings in the past and for the loss of his earning capacity in the future, reduced by the amount that plaintiff could have earned from comparable employment? $4 million. Number 4, what is the total amount of plaintiff Zachary Young's damages for pain and suffering, mental anguish, inconvenience, injury to reputation, and loss of capacity for the enjoyment of life that he sustained in the past and that he has sustained for the future? $1 million. Number 5, do you find by clear and convincing evidence that punitive damages are warranted against defendant CNN? Yes. Date, January 17, 2025, signed by the foreperson.
Okay, yep.
Hello, folks, and welcome to the show. We are gathered here to we are here because yours truly reached out. Well, actually, did not reach out. Somebody just pinged me on Twitter, and all of a sudden, there he was. But just to make a short summary. Zachary Young, a Navy vet who, after his career, started working in the private sector and with some 3-letter agencies, and then the Afghanistan withdrawal debauchery took place. Mr. Young decided, hey, I have expertise, I have knowledge, I have people, contacted a bunch of, or were contacted by, corporations and entities who said, we want our people out. And he got people out. Here comes CNN. Decided to make a piece about Afghanistan, which they claim were focused on this desperate Afghanistan. Now, if they have only done that, great piece, but they chose Zachary Young, who did nothing illegal, as their centerpiece and portrayed him as one of these more or less human traffickers who took advantage of Afghans. And a week ago, a jury in northern Florida decided, CNN, you know, just no, and awarded Mr. Young $5 million in lost wages and damages. And then just as after they said, yeah, we also find that there is cause for punitive damages, CNN settled. And the mastermind, or at least the attorney with an excellent team behind him, yeah, I must say, great work. And he also agreed on this interview, discussion, conversation. Everybody, give your warmest welcome to Mr. Val Freedman.
Hey, Nick, thanks for having me on.
Thank you so much for being here. Now, first of all, congratulations.
Thank you.
Second of all, how is Mr. Young doing now?
Very well. I think, as can be expected, he's very happy. He's back in Vienna with his wife and his dog Misha, and he's happy that both this is behind him, and he has what to move forward with, and he's cleared his name, which was always goal number one for him. So,
Yeah. Now, one of the things one of the things my audience wanted to ask is, how do you pronounce your last name?
Freedman.
It is Freedman. Okay.
Yeah.
Now you got the answer to that question, dear audience.
I've never done it before. I see on the right side all these folks commenting in real time. So hi to all of you out there. It's nice to meet you all. You've got a great host here. I really enjoyed listening to him.
Oh, yeah. Now, one of the things that everybody is curious about, and I have to ask the question, I do not expect an answer. The punitive damages, what did they settle for?
I can't answer that. I'm sorry. You know, they part of the terms of the settlement was that would be kept confidential. But I can tell you that Mr. Young is very happy, and so are we. So
now we here on this channel, we speculated. What would it take for Mr. Freedman to accept this and not push it forward? I mean, and now, of course, it's one thing what he deserves and one thing what is realistic. So, Brooklyn here, give a range.
what is it? Zero, less than $1 billion.
Okay, so it's more than a zero and less than $1 billion. Okay, that thank you. That keeps us in
very
narrow range.
Right? Very tight range. Yeah.
Very, very tight range. But one of the things.
But did you listen, Nick, to the punitive damages phase was ongoing while the parties settled, and I think shortly before the parties settled, I think Mr. Dulwich, one of my partners, asked our expert who had reviewed all of CNN's finances whether they could accept afford a 30-day timeout. And 30-day timeout was about $5 million in revenue a day. So you're looking at about 150 million or so. And his answer was that they could afford that. So while I can't tell you that has any indication of what we settled for, those were the numbers in play when the party settled.
Yeah, and I have to say, that witness you put on was worth every cent of $975 an hour. Now,
Yes, he was.
Yeah, I've listened to a lot of numbers, guys. In my line of work in labor law, when I negotiate big laydowns and stuff like that. Numbers, guys, I put on if I have trouble sleeping. I mean, but this guy made it really interesting. This guy could talk to a jury. And that's not common.
I'll tell you a funny story, Nick. When we were looking for our numbers guy, I reached out to one of my mentors who had taught me when I was kind of, growing up in the law. And I said, I need the best economist you've ever seen. I need the best guy you've ever seen. And he didn't hesitate for a second. He goes, Robert Johnson. You need Robert Johnson. Go call him. Then I called Robert Johnson, and he told me, Mr. Johnson, who testified for us, he says, I'm done kind of traveling to trials. I do them all remotely. I said, Mr. Johnson, you've got to come out for this one. This is a big deal. Like, this is against CNN. There's a lot of money on the state. Like, you got to come out. And he said, he listened to the whole thing. He said, let me think about it. And he called me back and he says, all right, I have family near there. I'll make it into a family trip. I'll come out. And so we were ecstatic. So he's your man if you ever need a numbers guy.
Oh yeah. I found myself rewatching it just because, I mean, I've been doing this trial streaming for over 2 years now, and I've heard a lot of numbers, guys. And this guy, absolutely exceptional. Without being patronizing, he could dumb it down and put it in context. And so that is a rare quality. That is a rare quality. And if he ever moves to Sweden, I would suggest to my employers, hey, how about this guy? Yeah, so that was very, very, how he worked it out just at $4.9 million a day, and then worked around and how he dismantled. Was it Mr. Axelrod who did the cross-examination?
Yes, Mr. Axelrod cross-examined Mr. Johnson. I will tell you that I missed most of it because I was out of the courtroom negotiating with CNN when that happened. So I did not see the cross.
Oh, he let's just say Mr. Axelrod was effectively dismantled in the cross-examination. And it was very, very joyous to see. And speaking of dismantling things, the judge you managed to have in this trial, he, first of all, the female part of my audience really liked him. And second of all, when the thing that got viral was his $100 per ad hominem attack against each other. Was this exceptionally, in your experience, exceptionally harsh between the attorneys?
I didn't think so. I didn't think so. I it's always easy to say this, but I felt that the animosity was really coming in one direction. We were really receiving a lot of it. And what I found is that judges, in an effort to appear unbiased and bipartisan, will usually kind of yell at both parties for something one is doing, right? So one might do something, you both are doing all this. This is terrible. You both got to stop. And I felt that was a little bit of what was going on there. But yeah, look, I have no complaints. Judge Henry, I have said this before. I'll leave the look comments aside to your female audience, but I will tell you as a jurist, as a judge, he is one of the smartest judges I've ever practiced in front of. That man knew questions before we were able to ask him. We'd be listening to CNN, and we'd have a little chat group of all of our team, throwing up, brainstorming ideas or problems that with their arguments. And before we could even ask them, Judge Henry would look at CNN's lawyers and ask the questions, and it got so creepy that we were saying, "Oh my God, is this judge telepathic? Like, is he reading our minds to know all the questions he has to ask CNN?" He was brilliant. He was attentive. He knew all the details of the case. I didn't always agree with his rulings, obviously, especially when I lost, but he was just phenomenal. We got very, very lucky to have him, and the Florida bar is very lucky to have him as a judge.
Yeah, definitely. Really, how he almost always paused. He really thought things through. Okay, he probably already knew what he was going to say. It's how is he going to say it. But I was thoroughly enjoying, because I've been seeing trials which have had less than stellar judges. I don't know if you have seen anything about the YSL trial, but Chief Judge Glanville was recused for an illegal ex parte. That was interesting. So yeah, I've seen a good share of less than stellar, but then there are judges that just are good and ethical. Like this one, you had the judge in the Depp v. Heard case, who was exceptional, in my opinion, in her approach to the parties. And so when you come across these, you really want to watch them in other cases. Yeah. And now, one thing that I've been very, very curious about. Mr. Jingles, my share is not a scratch poll. I know you think. You have 5 scratch polls, Mr. Jingles. Why my share? Sorry. One thing that I've been very, very curious about. When you opened when you got to Discovery, when you opened the first set of emails, what was your reaction?
Well, we were, it's a mixed reaction. So somebody asked me this question before, and you're excited that you're seeing what you know is great evidence for your case. So from that perspective, it's very exciting. But at the same time, it's kind of disheartening, because you want to believe that your news is unbiased and, just fair and not out with an agenda. And that became very hard to believe as we began looking more and more into the evidence that we saw in front of us in our case. It was just, when you call somebody and we're going to nail this Zachary Young mother effer, when you call him a shit, when you call him I don't know if we can curse on this channel, you call him an S-bag, an a-hole, you start going down this path. He's got a punchable face. It's your funeral bucko, for F's sake. I mean, it's like you read it through and you go, oh my God, So at the one hand, super excited that we now had great internal evidence to prove what we thought was the case, but also in some ways it's kind of disheartening.
Yeah, it was an interesting insight in the inner workings of a news organization when one or a handful of people decides to, how can we, as they said, nail this guy?
Yeah.
And the level, it went up to Mr. Levine. I mean, he's a high up in CNN.
Well, I don't know. I have a lot of respect for Adam Levine. His documents were very clean. He had no bad documents. He didn't get in on that, trashing Young party. He did tell Marquardt early on that the story he was working on was good if he has these examples. But that to me is sound advice, right? Which is like, but make sure your examples are real, not that they're fake. And then he got asked to be the corporate representative for CNN. So now he got put in an impossible position where he was asked to both, say that they weren't sorry, but defend the fact that they had said they were sorry. And I thought he did as good of a job as anyone could have. I thought he stood up well to the cross-examination. And like I said, since he wasn't involved in any of the kind of shenanigans that we saw, I have a lot of respect for him. So I wish him the best of luck.
I have a question here. How did they get all those internal discussions? Yeah. Well, what now? Getting to discovery in a case like this is very, very rare. But what was the decision from the judge that made you go to discovery?
So in Florida, in the United States, obviously we have these broad discovery rules, and as soon as we lodged our complaint, CNN gets a chance to move to dismiss it. They can ask the judge to freeze discovery pending a ruling on the motion to dismiss. They did not do that. They also were never going to win that motion to dismiss, so I think they knew that. And so as an operation of kind of just normal law in Florida, the next phase is to begin fact discovery. And what we do is we send out, just to answer the question directly, is we send out what we call requests for production. And it's a request to the other side with the enforcement powers of the court that says, give us all documents that relate to, and we get to say. And so one of the things we asked the other side, we sent them a request for production to CNN, and we said, hey, please give us all communications that relate to the story Zachary Young, Nemex Enterprises, or something of this nature. And then it's on CNN's lawyers to go in, collect those documents, find them, review them, and produce them to us. And if they fail to do that, obviously, then we can bring discovery sanctions and things against them like that. So we asked for those documents. They produced them over to us as part of the normal functions of the court process.
Okay. Thank you so much. I got also... let me try to translate some of the questions here.
Sure.
What especially caused you to... Well, I don't think you hate Mr. Axelrod.
I think that's right. I don't hate Mr. Axelrod.
Yeah, but let me turn it around instead. What do you think made Mr. Axelrod... Because Mr. Axelrod is a seasoned attorney, very seasoned attorney.
Sure.
What do you think was his... Why did he seem to have such animosity against you? And not you as a person, but you as a team and defendant.
That's a strategic choice he made. I don't know why he made that. I can tell you, I'm obviously, as you can see, I look a lot younger than I really am. So let me lead with that. I have a 14-year-old daughter, so I'm a lot older than I look, but I know I look like I'm 15 years old. I think that has an effect on older and more accomplished lawyers. And I'm not saying that this is what happened with Mr. Axelrod, but sometimes you'll see older folks kind of underestimate younger folks or have animosity for younger folks who are handling cases that the older folks don't think they should be handling. And, we just don't let that bother us. We just keep doing our job and thank God we've been very successful. But sometimes that can contribute to some perceived animosity where they think, well, why are you here? Why are you doing this? How long it took me to be here? That sort of thing. So I don't know if that's what animated Mr. Axelrod, but that's. And by the way, I mean, like Mr. Axelrod and I shook hands when it was over, and it's not like we're not sitting here, conspiring on how to hurt the other person. It's professional. This is our job. This is what we do. We've moved on to the next case. So I wish him the best of luck.
Yeah, I mean, as an interesting some 10, 15 years ago, I got a new boss. She was barely out of university. She was this barely 5 foot blonde girl, and she knew it. She knew how she looked, and then we paired up in certain cases because she was the lead. But we portrayed it as, no, I go in first. I mean, here comes, I look like a union rep. 6'4", close to 300 pounds. Yeah, I look like a union rep. And then she walks, and then I walk out. Because they believed she was my, note taker or something. That was interesting. And they talked in front of her.
That's crazy.
And then we introduced ourselves. Then it was, say what? So that was, yeah. So yeah, she knew exactly what she looked like and how to use it to her advantage. But nowadays she's very well known, and everybody's scared of her because she can dismantle you in minutes if you don't have your facts straight. And I'm very, very privileged to have worked for her. She taught me a lot, actually. And that's sometimes hard for an old fart like me to admit. Sometimes it's hard to admit. I have another, this one. Do you know what the jury would have awarded? Did you talk to the juror?
I do not. Lawyers are prohibited from affirmatively reaching out to the members of the jury. They are allowed to reach out to us. They have not yet. And the press can reach out to them, or others can reach out to them. So I'm very much hoping to eventually talk with them. I would love for them to reach out to me, but I have not yet talked to them. So I do not know what they would have awarded. It's also a little bit of an unfair question because they didn't finish hearing all the evidence, right? So, Mr. Johnson was done his presentation. CNN had their presentation. We had the deposition testimony of CNN's CFO that we were still going to play to talk about their profit margins, their revenues. And so they didn't hear all of that. And at the end of the day, the punitive part of trial is to fashion a punishment. And part of fashioning a punishment is knowing how much the defendant can afford, right? If Bill Gates or Elon Musk is speeding through your town and you hand them a $10 ticket and you say you can't speed through here, the question is going to be, well, how many more miles is it? Here's $100. Like, I'm going to speed through the rest, right? So you got to give a punishment that'll actually punish. And so they needed to hear, like, how big is CNN, how much revenue are they bringing in, how much are they worth, how much can they handle, what would not bankrupt them, but what would hurt them. And then we were going to make a plea for that. And so I don't know that we'll ever get an accurate assessment of what the jury would have awarded.
Now, because this was called the $1 billion lawsuit. Then in lost wages and damages, lost wages alone was the 21 million he asked for, Mr. Young. Do you think that once the jury came back with quote unquote a reasonable amount, did that scare CNN into settlement? As in, we can't successfully appeal this. There's no way to draw away money.
I don't know what was going on in CNN's mind. Press did run with it as $1 billion lawsuit, and there were some very complicated shenanigans that could have gotten us to $1 billion. Whether that would have actually been held up on appeal, probably not, Nick. But you can't source that number to us. We did ask for the 21 in work. We knew that was, it was a hopeful number, meaning it was a number that we were hoping the jury would give and that there was a basis for, but we also were cognizant of where we had filed, right up in the Panhandle in Florida. That's a lot of money. $5 million is a lot of money for those people. And you make all your money on punitives anyways, Nick. That's really where the money gets made, right? Because there you can get multiples and multiples of what you got below in the compensatory stage. We were fine with the $5 million. I thought that was pretty reasonable from the jury. I thought that was a good number for us. And we were ready to go into the punitive section. As you saw, we immediately put Johnson up. So kind of hope we'd have found out what the jury would have awarded, but unfortunately we don't get to find out. But by the way, that's why I told you between 0 and $1 billion, because the press had been calling it $1 billion. So I said less than $1 billion.
Yeah. Now, I stumbled upon this trial. I came in a day late. I was supposed to cover one of the hearings in the YSL case, and it didn't happen. So I just, okay, what on? And then I thought, why haven't I heard of this case? This should have been an enormous case in all the press. And then I realized, wait a minute, it's against CNN. For a hit piece. No wonder why nobody is covering this, because the format is not unique for any major news organization. They might have had an incentive to not cover this as much as other trials, maybe.
We found a lot of resistance to covering the story. A lot of news outlets were not interested in covering it, despite how significant of a case it was. It was a case where, especially so in Florida state court, in order to get punitive damages, you must first have the courts say whether or not it's reasonable for you to seek them. And many, many cases die there. The courts won't allow you to seek punitive damages. Not only did we pass that hurdle, meaning not only did Judge Henry say, I've seen the evidence and you have enough of a basis to ask the jury for it, CNN took an immediate appeal to the First District Court of Appeal. And the appellate court found that we had done it too. So there were 2 courts that had reviewed this, 4 judges, 3 on appeal, 1 below, who had said we were entitled to seek punitive damages against a national media entity for defamation. As far as I can tell, we're still trying to find it, but as far as I can tell, this is the first time a mainstream national media organization has been held liable for punitive damages in like 50 or 60 years. It was a big deal, but folks weren't really covering it until the trial started coming. There was one news organization that really did cover it from very beginning on. They were called Newsbusters, and they hold themselves out as like a conservative media watchdog. And so they covered it extensively. And Nick Fundacaro. And actually, Nick was one of the people, I don't know if you saw, there was this portion of the proceeding where CNN was trying to get the camera shut off for one witness. And they had represented to the court that the media didn't object to shutting the cameras off. And Nick stood up and he said, nobody asked me and I object. And he had been covering it from the very beginning. So they had covered it very, very early on. At some point, Fox began covering it too. And they covered it pretty extensively. And then slowly other folks got involved. And by the end of it, everyone did cover it. I mean, the Wall Street Journal ran an article, the New York Times ran an article, the Washington Post ran it, the LA Times wrote an article. So all the big media did eventually cover it, but there was a lot of pushback in the beginning. And I don't know why, but it wouldn't surprise me that the media is a little uncomfortable with where this lawsuit was going,
Yeah, I mean, when I started, I had maybe 50 or 60 people watching. And last day I had over 1,000 continuous. So you could see the progress, and I could see it coexist with, now this news outlet is writing about it. Now this newslet is writing about it. And all of a sudden it got interest that, in my opinion, this case should have had from the beginning. But As we might even conclude that, well, a major news organization being sued for defamation for a piece that is not uncommon to do in major news outlets. Now, I have one of these. Let's see here. I saw a question earlier. One of the things that Mr. Gosney, by the way, is a civil attorney in Miami, who believes there were many objections missed by Mr. Axelrod, and how he claims they might have been portrayed themselves as very unlikable. Do you agree with many missed objections from them?
You know, objections are a strategy call in trial, because when you object, you do two things. One is, if you win your objection, you keep evidence from the jury. The jury knows you've now kept evidence from them. So you signal that you're scared about what's coming, and you signal that, you want to keep something from them. If you signal you're scared and you lose, now the jury pays a lot more attention to it than they would have otherwise paid attention to it. If you signal you're scared and you keep it out, the jury is now wondering, what did you keep out? And so Mr. Gosney's right. There were many opportunities to object at our direct examination, our cross-examinations. There were many opportunities for us to object on their examination. But it's a little bit of an art of when you're going to object and when you're not going to object. And I'll give you an example. I don't know if you saw, but there was a portion of the cross-examination of Thomas Lumley where we put up an email from a CNN reporter called Nicole Gowett. And Miss Gowett read the article or watched the clip. She wrote to Lumley saying the inference running through the article that these people are just bilking these Afghans for their money may not be fair at all. And remember that one of our claims was defamation by implication, meaning that they created an inference that was unfair, that was not true. And so this email was just unbelievable smoking gun evidence. It was a inside person at CNN before the digital piece went on who told CNN this inference may not be fair. And when I went to introduce that document, which was an email from CNN to another CNN person, that person was on the stand. There's no way that email wasn't coming into evidence. Mr. Axelrod jumped up and objected. And the court ended up taking a break and dismissing the jury, and we argued it. And of course, it came in. And then right after lunch, they came back and I said, hey, we were talking about this email. Mr. Axelrod objected to, this is the email now. And now everybody was looking at this email, and it's a big deal. So Mr. Gosney's right. He's right. But, I haven't gone over the film with a fine-tooth comb to see whether I disagree with the strategy calls. But there's reasons not to object, even though you could.
Yeah, and you also have the... let's see, Mr. Lumley, that was the editor.
He was the editor, yeah.
Yeah, that I missed that the first time around because I was trying to catch up. It was in the middle of all the depositions, and thanks to you who directed me to it, because you thought I would find that very, very interesting. You were absolutely correct. It was a very, very interesting, and I told you how I can't. Well, let's put it like this. If CNN have listened to him, this trial would never have happened, because CNN would not have had Mr. Young in that segment if they only listened to him. But it seems like Mr. Mark Quad, we had a. Let's just say his name reminds of something completely else.
Lord Farquaad from Shrek.
Yeah, so there were some intentional mispronunciations through the coverage of Mr. Marquardt. And again, the deposition of him, you could we talked about it earlier. He was not prepared. He really wasn't prepared for that. And a few of the other depositions, I'm thinking of Miss Kate. let's see here, what was her name with the interesting haircut?
Emma Lacey Bordeaux.
You know exactly who I mean by that, yeah. Yeah. Also, for that level of education, surprisingly unprepared. Was this something you realized early on, that these people are really not prepared for this?
I don't think so. We didn't have an opportunity to know whether they would or would not have been prepared. You know, we did depose them once before. I don't know that I agree with you that Miss Bordeaux or Miss Lacey Bordeaux, I think she wanted to be called, was unprepared. I actually thought she came across as quite genuine and honest. And that was a stark contrast to some of the other witnesses that CNN put on the stand to me. And I did think that, you know, going through her documents, I knew, because I had crossed Emma Lacey Bordeaux, and going through her documents, I knew I wasn't going to be able to portray her as kind of this willful bad actor that we were kind of setting up Lumley for and setting up Marquardt for and Katie Bo-Lillis, because her documents were too clean, kind of like Adam Levine.
Mm-hmm.
She did give some testimony that I thought was a little too convenient, like, she had said in writing that 2 hours was a sharp turnaround time, but then she walked that back and said, then I found out we had talked to her for a while. But when I walked her through the actual evidence of what had occurred, she kind of pulled back and she went, well, I'd have to think about whether or not 2 hours would really be enough. And at the end of the day, she's a CNN employee, so I understand why she's not going to throw him under the bus. But I thought that was genuine. I thought that was forthcoming and honest. She had some other admissions. I thought by the time she got off the stand, we had effectively shown that at a minimum, Miss Lacey Bordeaux was negligent in her performance of her checking. You know, she didn't check the banners. She let somebody else check the banners. She relied on them. She kind of relied on them to tell her that 2 hours was enough time, even though it really wasn't. So I thought that we had gotten that out from her, and that's as much as I thought we were going. That was the juice we were going to squeeze from her testimony. But I don't know that I think she wasn't prepared. I thought she was. I thought she did a good job. She was one of their best witnesses, I thought.
Okay. Interesting in how we perceive different things. I know for myself, when I am very in a case, I tend to get a bit tunnel visioned. So now when I'm not covering, I might have, I can allow myself to be a bit more, not conspiratorial, but wider in my assessment.
Fair enough. Look, you know, I suffer from the same thing, right? Because I'm so dialed into the evidence of the case and the presentation. It's possible I missed things that you guys picked up on, and so, happy to hear your perspective. I'll go back and watch it and see what I see. Maybe it'll revise my opinion. You know.
Let's see here. Steve Gosney says, "Visit Miami, Nick." I actually am. I'm going to Miami in September.
Oh, great.
Yeah.
Let me know what you're here.
I will be covering a YSL Melly case, the retrial, that starts in September. So I'll be trying to sneak into the courtroom as I did in the YSL trial in Atlanta. I got into the courtroom because it's a whole other. Watching it on screen is one thing. Being in the courtroom and listen to what happens in the breaks, completely different. You get a completely new notion of what's actually going on, and I really, really like it. So yeah, I will be visiting Mr. Gosney in Miami in September, and I understand you work out of Miami.
I do, yeah. The firm I started has offices in New York, Miami, and Boston, but I'm based in Miami. Our cases take us around the country. We work around the country, but I live and work in Miami on a daily basis.
Yeah. So you were, what we call it, not sequestered in. It's called, you had a local, what's the word I'm looking for here? Because I remember the judge giving a slight warning for I know Mr. Axelrod was brought in. He did not have a license, so you have to have a person at place to vouch for you. And I remember the judge saying that that was very, very subtle. I don't know if all caught it, but when he said, "Who you bring in reflects on you as well," and I was a, oh, that was an interesting comment.
He was not happy with Mr. Axelrod. I think that was again directed at Mr. Axelrod. But no, I'm licensed in Florida, New York, and DC, so I can practice all over Florida. Mr. Axelrod wasn't licensed in Florida, so he had to what we call it's a Latin term, but it's called pro hoc vice. And so he has to get the court to basically allow him to act as a lawyer in this case, even though he doesn't have privileges to practice in Florida. And that's common. It's routine. It's done all the time. You have a client that has a court case in some other state. They want their go-to lawyer. The go-to lawyer finds a local lawyer who will sponsor them and says, I'll watch over this guy, but he's a lawyer in this other place. Let him practice. So that happens all the time. And some of my partners are only licensed in New York or California, or, and so they came into, like, for example, Mr. Dulwich, who crossed Mr. Hogan and who took the direct of Mr. Johnson. He's only barred in New York. So we had to pro hoc vice him into Florida, and I sponsored him for Florida. And that's what that warning was about. Like, oh, you're responsible for all your lawyers. I'm not worried about my lawyers. I think Deanna Roman, who was the local lawyer that had sponsored Mr. Axelrod, I think that was a little warning to, across the shot, across the bow to her.
Yeah, because that was right. Not that long after he raised the fines to $1,000 per insult. And hearing that as a sponsor, that she might be co-responsible for those fines. Now, I don't know if he actually pulled the trigger on that. Do you know that?
The $1,000 fines he did not pull the trigger on, no. But he did have me and Mr. Axelrod pay. If I don't even remember. I think it was maybe $200 or something each at some point. He didn't give any details. He just came in one time in the morning. He's like, you crossed the line 2 times, so $200, and you did it, so $200. I was just like, okay. It was going to charity anyways. So.
Yeah. As one of my other LawTube friends said, could you have stand up and said, can I depose $1,000?
Can I depose $1,000?
Yeah, when he said that $100 fine if you do the ad hominem, and you could say, "Can I deposit $1,000 and just go at him?"
have a credit to go. I don't think that would have went over very well.
No, I suppose so. That is the one thing that is fun for me, as I could never do that in my practice. Here, it's fun. It's fun. Oh, I have a new question from Mr. Gosney. Would love to hear the thinking behind the venue choice, i.e. conservative North Florida juries versus other parts of Florida. That's an interesting... Was this a deliberate choice, this part of Florida?
So first of all, Nick, I should ban you from having lawyers in your chat asking very legal or Mr. Cosby really knows how to get to those great questions. So yes, we purposely filed up there. And why? Because for 2 reasons. So first of all, back up one step with me. As a lawyer, we have a duty to do everything we can to help our client win the case. One of the tools at a plaintiff's disposal, meaning one of the tools at the person who's going to be bringing the case, one of the things that the courts allow him to do is choose his venue. Where do you want to sue? You get the opportunity to choose where to sue. And the courts have dealt with this specifically, meaning not only do you get to choose where to sue, you can choose where to sue for any reason you want. If you think that the people in that area are better for you, the judges, the law, that's all permitted. It's one of the benefits of being the plaintiff. Now, there are downsides. You have the burden of proof. You have to prove your whole case. The defendant can sit there, do nothing, and if you haven't carried your burden to prove your case, you lose. So there are benefits and downsides. This is one of the benefits. Why we have filed up there was for 2 reasons. First of all, the judges up there we knew had a great reputation. So there's, like, for example, down here in Miami, you've got tons of judges. So you don't know who you're going to get. Up there, there's a lot less, and they all have a great reputation. So we thought, okay, number one, we're probably going to get a good judge. We don't know who exactly, but they all had a great reputation up in Bay County. So we said, okay, number one, we're probably going to get a good judge. Number two, the First District Court of Appeal, which is the appellate court that sits above that, is also a phenomenal court. Really bright judges. They do their work quickly. They do it right. There was some good precedent there. So number one, we got a good trial court. Number two, we were going to be operating with a great appellate court. And number three, the research we did before the case showed us that Republicans were more likely to hold the media to account than Democrats were. And I want to be clear about this, because this wasn't like we want Republicans because they hate CNN. That's not what our evidence showed. What we saw was that Republicans and independents were more willing to hold the media to account, regardless of who the media was, than Democrats were. That's not to say Democrats weren't willing to do it either. They were. And in fact, I think our jury ended up being 3-3, 3 Republicans, 3 Democrats. If I remember correctly, I think it was split evenly. So, but because we knew we were trying to hold the media to account, and we knew that Bay County was 73% Republican, we ended up filing up there. So there was 3 reasons why we chose that. And this ended up becoming an issue later on in the trial. CNN started putting in its filings that they were going to argue that Zach was opportunistic by filing up in a Republican county and things like that. So we filed what we call a motion in limine, which is a motion to stop them from saying anything. And we said they can't raise our choice of venue in Bay County into the jury. It's completely inappropriate. We're within our rights to be in Bay County. Here's why. CNN agrees we're here properly. The law permits us to do this, and we are entitled to choose where we want to go. And that's legal strategy. It's not even Zach. It's his lawyers that are deciding it. And Judge Henry agreed. He said, you cannot mention this venue choice.
Yeah. Now,
let's limit Mr. Gosney's further questions. Yeah.
Then one of the highlights, in my opinion, do you think CNN's witnesses were coached in the way they described black market, both in trial and in depositions?
Well, I'm gonna do a very Jewish thing to you, Nick, and I'm gonna answer your question with a question. Can you tell me how you believe 7 people all chose the same definition of a word that does not exist in any dictionary? So all 7 people landed on the exact same definition. That definition is not contained in a single dictionary. And not only that, the dictionary refutes that definition, right? Because their definition was unregulated. And according to Webster's, a black market is an illicit trade in violation of official regulations, meaning there must be regulations to violate to have a black market. So you tell me, Nick, let's ask you the question. How do 7 people land on the same definition of a word that has absolutely no source or citation?
Well, how to answer this as neutral as possible, because it is unethical to you cannot coach answers as an attorney. But I don't have a skin in the game. I would say you coach them, because it's the only defense. We believe these words means this. And when at the beginning of trial, I saw, no. And then the next one, oh, this isn't happening. Because I explained to everybody in my audience and me, an unregulated market is a gray market, because you don't know if it's legal or illegal. As soon as it is regulated, you have the divisive in white market, black market. I mean, that has been the definition for centuries.
Look,
since we began trading 5,000 years ago. I mean,
they tried at one point. I don't know if you looked at this, but they tried at one point to argue before trial started that what they said was true, that it was, even if you accept that black market means illegal, it was true because Mr. Young's actions were in violation of the Taliban's rules and regulations and Sharia law. And we just blew him up in response. We're like, are you serious right now? Like, these are a group of terrorists that are murdering women, and that is what you're claiming, that this is illegal because of these terrorists? And the judge was not having it. He put in his order, like, that'd be like saying that the Nazis' extermination of the Jews was like somewhat okay, so that that would be, I don't remember his exact words, but he was saying the parallel, claiming that the Taliban's rules were law would be similar to saying like, oh, people that smuggled Jews out of Nazi Germany were breaking the law. And he said, this is a bridge too far. Absolutely not. And he denied it and precluded them from arguing it. So
yeah, I understand why, but also I wonder what would have happened because that would have been, if they argued that in court
to the jury,
live. Yeah, I think the punitives might have been higher. let's just say that. Now because sometimes a tiny part of your job sometimes is to, that's too stupid. Don't do that against the counterpart. Now you always want a fairness between the parties. But also, sometimes, if they trip up, then they trip up. But at this point, that's really, really a bad idea. And CNN can argue ineffective of counsel. And you have appellate issues and all of the things. So sometimes you have to stop the counterpart from making too big of mistakes.
I see it, Mr. Jingles to sleep. Maybe I've overstayed my welcome. I should...
He either sleeps, bothers me, or brings in unwanted gifts. So that is standard. Mr. Genius is the true owner of this channel. I'm doing this so I can afford snacks and stuff to Mr. Genius. Let's see here. I had one more. Now we do know that there will be I assume there will be no appeals, that is a part of the settlement. So that question is, here's a good one. What advice would you give someone considering a defamation lawsuit?
Oh, that's unfortunately just way too generic. It's like going to a doctor and saying, what advice would you give somebody whose head is them? It depends on so much.
Let's see if I can make.
Wait, Nick, got it. Hire me.
Yeah, you have offices in Miami, Boston, and New York. I mean, and you work all over the country. So yeah, go talk to Mr. Freedman. Now, one question. Now, I sort of already know the answer. What is the highest official settlement or highest award you have in your practice? We
brought an antitrust case against the top 16 universities in the United States for violating the Sherman antitrust laws, and I think 7 or 8 of them settled for $284 million.
That's quite good.
So,
and
I'm not going to tell you. I'm excluding this case, so because again, it's confidential. I can't tell you whether this was higher or lower, but that was the highest publicly disclosed settlement we've entered into.
Yeah. And now the follow-up question I had, because I also read through your webpage and have some of the official numbers. And I now I don't do math. Somehow we lawyers don't do math. But did this, in a ballpark, get your law firm above $1 billion in total damages awarded?
Well, I think because you are trying to compute things up, I've got to be real careful here. I can't. I'm trying to answer that one. You got some sneaky questions, Nick, but I got to decline it. We've recovered a lot of money for people, thank God, and we're very happy and very proud of that. But unfortunately, I'm gonna decline on responding to that one.
I gotta try.
It was well crafted.
Yeah, I mean, gotta try. Now we're approaching an hour here, and Now, you're welcome to stay as long as you want, but we both have things to do, and it is now 2 a.m. my time.
Oh my.
Yeah, I'm 6 hours ahead of you. The question is, what is next? What is in your pipeline that we might see in a televised trial?
You know, we do a lot of work in federal court, and the federal courts don't allow trials to be streamed like that. It's really state courts that allow that. So I don't know when you'll see another streamed trial, but we've got some great cases. That antitrust case against the colleges is still moving forward. We've got a great case against NASCAR that's pending in state court in Miami for the Let's Brandon debacle. I don't know if you're familiar with that. But
I am not. Please send over the information so I can check it. That would be really interesting.
Yeah, it's a really cool case, actually. And Mr. Dulwich is actually leading that for us. And he was one of the partners that helped on this case. So that's exciting. You know, we've got some more run-of-the-mill cases, some trademark disputes and things like that. But let's see here. What's an interesting? So the Let's Go Brandon one is really cool. That's pending in Miami.
Wait. You have a Let's Go Brandon case?
Yeah. So the NASCAR case, it's against NASCAR for, we represent this foundation that created a cryptocurrency token called Let's Go Brandon after NASCAR authorized the use of the Let's Go Brandon mark on their cars. And then what ended up happening was they then published that they had not authorized it. We allege in violation of what they had previously already done. And then when they made that announcement, everybody thought, oh, this token is just garbage. And it dropped in market cap from, hundreds of millions to almost nothing. So it's a similar defamation style case, similar, breach of contract style claim. And that's pending in state court. So I'm mentioning it because it'll be, I don't know if the judge will allow it to be live streamed, but that has the capacity to be live streamed. So,
well, I can always file for, I don't know if it's called Rule 22 in Florida as well, but you have excellent laws and statutes regarding, your open records laws are excellent. Hence, Florida man and every meme around it. And
yes, that's true. So we've got some cool cases. We've got a great case against Grubhub and Uber Eats for antitrust violations that's now on appeal in front of the Second Circuit. We won, and the defendants appealed on an issue of arbitration. We've got a great case against TikTok for multiple different things, but including what we call a mass arbitration, where we have alleged that their algorithms are unreasonably dangerous and also violate certain wiretapping laws. And we actually, there's a company we're working with called Claims Hero. I think it's claimshero.io, so I'll plug them, where you can kind of go and look and sign up for these cases. And so we've got, representing thousands of people against TikTok in these claims and arbitration. They've brought us to federal court to try to stop the thousands of arbitrations we want to file. And so we're litigating that in federal court while we kind of pursue this forward in arbitration. So thank God, we've got a lot of really cool cases.
That sounds amazing. Now, I hope to keep in contact and maybe have a meetup when I get to Florida in September. I will be landing the 18th and be flying out the 24th. Now, you're a busy guy, I know. And but if we can make it happen, I would be really, really honored. Now, here is one last question. Are you aware of any other suits coming down the pipeline because of the conclusion of this case, the defamation case against CNN?
Yeah, I mean, we got a lot of people reached out to us, that's for sure. And we're kind of going through them to see what we would take on and what we could take on and what we want to take on. I do know there's another big defamation case that's pending out there. The Hams, Mr. and Mrs. Ham, are suing Netflix for defamation, and they attended some of our trial, I think, to kind of just get a sense of what they were in for when it came to the end. And they're just a lovely, lovely couple. And I know that, so Nick, you should make sure to follow them.
Okay, I will be searching for it. Definitely. Yeah. Well, the reason my reaction, we have a person who's usually in our chat who calls himself Let's Go Brandon. So that was just very, very amusing. And we all know the history about the chant in the stadium and the reporter who, they are shouting, "Let's go, Brandon." No, they weren't. Yeah. But first of all, thank you a lot for agreeing on this interview discussion. It has been very enlightening. And I hope to be able to keep in touch, especially me as a streamer. If you have a case is going to trial and eventually going to be live streamed, you're more than welcome to plug the case here on this channel.
As I told you before, when we were chatting quickly before the show started, my wife and I got sent a clip of your show. We were in bed about to go to sleep, and we watched it, and we were just rolling. I mean, you're so talented and so funny. And so that's why I just said, hey, good work. A lot of planning goes into these lawsuits. You don't just get up and just talk, right? I mean, and and nobody really sees it besides the jury, the judge. And so it was really funny and nice to see people look at it and go, wow, like this is well-crafted setup. And we really enjoyed it. So happy to come here and keep up the good work.
Thank you so much. Now, do you have any final words for the viewers here?
Not really. Just stick with this guy. He's great. He's entertaining. He's fun. He's a breath of fresh air in some of the more traditional media. So, Nick, keep it going. And I would love to meet with you when you come down to Florida. We'll stay in touch and we'll see if we can figure it out. Just don't bring Goski because he's going to ask me some.
Maybe he will be nicer in person. All right. Thank you so much. And everybody out there, thank you for tuning in. Thank you for the excellent questions. Thank you for, hit the like button. Subscribe if you haven't done it yet. And if you have a defamation case, Val Freedman just got Mr. Young we know 5 million and then an undisclosed amount of pocket money. We will see if we will catch Mr. Young in a yacht show buying a 100-footer or not, but those are hard to deploy from Vienna. All right, everybody, thank you. Thank you, Mr. Freedman, and everybody, have a good one. And remember, hug your family. Unless they are crap, then screw them and give your love to the people who deserve it. All right. See ya. Bye-bye.
Bye.
Twisted threads of truth, laughing in the face of chaos, burning knowledge like a ruthless youth. Complex thoughts dance in the fire, cynics grin with a wisecrack's ire. Shadows with sharpened wits, baring teeth in a world unfair. We're the one with biting tongue, heart and brain a lethal arm. Stand unshaken, minds collide, laughing with the storm inside. We're the one with biting charm. Test, counting past through blackened skies, inside clear and bloodshot eyes. In the maze of thoughts ensnare, every joke a blade prepared, cuts through lies with humor.